National Health Security (ACT). Section 1. This section states the name and the effective date of the Act. Section 2. This section states that the Act shall come into force from the day after its promulgation in the Government Gazette. Section 3. This section defines the terms used in the Act, such as health service, service unit, network of service units, fee, fund, board, office, competent official, and minister. Section 4. This section states that the Minister of Public Health shall be in charge and control of the enforcement of the Act, and shall have powers to enact the ministerial regulations or notifications for the execution of the Act. Section 5. This section states that every person shall enjoy the right to a standard and efficient health service as provided in this Act. The Board may determine that, at each visit, beneficiaries of the health service shall contribute a fee at the specified rate, except for the indigents or other persons whose contribution is exempted by the Board. The type and scope of health service entitled to a person shall be as prescribed by the Board. Section 6. This section states that any person intending to exercise the right pursuant to Section 5 shall apply for registration at the office or the agency, as specified by the office for the purpose of selecting a service unit for regular visitation. Registration for a choice of service unit or application for a change of the service unit shall be in accordance with the rules, procedures and conditions as prescribed by the Board. In case a person is entitled to select a service unit according to other laws or rules, the exercise of the right to health service at a service unit shall comply with those laws or rules. Section 7. This section states that a registered person shall exercise the right to health service at the service unit of their own choosing, or a primary care unit, within the relevant network of service units, or another service unit thereto he or she is referred by their service unit or the relevant network of service units, except in case of justifiable cause, accident or emergency illness whereby the registered person shall have the right to access another service facility, as prescribed by the Board. In such case, the service facility shall be entitled to reimbursement of the expense from the fund pursuant to the rules, procedures and conditions as prescribed by the Board. Section 8. This section states that a person entitled to the right under Section 5, who has not registered pursuant to Section the 6th of may access any service unit for the first service. In such case, the service unit providing service to the person shall arrange for the registration of a service unit of person's choice in accordance with Section 6, and notify the office within 30 days from the date of service, and shall be entitled to reimbursement of the expense from the fund pursuant to the rules, procedures and conditions as prescribed by the Board. Section 9. This section states that the scope of the right to health service of the following persons shall be in accordance with the laws, rules, regulations, notifications, resolutions of the Council of Ministers, or any order provided for government agencies, local government organizations, state enterprises or other state agencies. The exercise of such right shall comply with this Act. Government officials or employees of government agencies, officials or employees of local government organizations, officials or employees of state enterprises or persons performing duties for other state agencies, or any other person entitled to medical treatment borne by the state budget, and parents, spouse, children or any other person entitled to medical benefits based on the right of the persons under 1, 2, or 3. The section also states that determination as to when a person of any category or agency under paragraph 1 may exercise the right to health service according to this Act shall be according to the Royal Decree. In case the Royal Decree under paragraph 3 comes into force, the government agencies, local government organizations, state enterprises or other state agencies, as the case may be, shall allocate the budget for medical expenses of the persons so provided by the Royal Decree to the fund in accordance with the rules, procedures, and period mutually agreed with the Board. Section 10. This section states that the scope of the right to health service of the persons eligible under the Social Security law shall be in accordance with such law. The extension of health service under this Act to the persons eligible under the Social Security law shall be in conformity with the agreement between the Board and the Social Security Board. The Board shall ensure the availability of health service for the persons eligible under the Social Security law, and, upon agreement with the Social Security Board. Section 11. This section deals with the reimbursement of health service expenses from the Workmen's Compensation Fund, WCF, or the employer to the National Health Security Fund in case of work-related injuries or illnesses. The WCF is a fund established by the Workmen's Compensation Act, BE 2537, 1994, to provide compensation and benefits to employees who suffer from work-related accidents, injuries, disabilities, or diseases. The WCF is administered by the Social Security Office, SSO, under the Ministry of Labour. The WCF covers all employees in Thailand, regardless of their nationality, except for government officials and employees of state enterprises. The WCF is financed by contributions from employers based on the risk level of their business activities. The contribution rates range from 0.2% to 1% of payroll. Employees do not have to contribute to the WCF. Section 12. This section deals with the reimbursement of health service expenses from the Victim Compensation Fund, or the vehicle insurance company, to the National Health Security Fund in case of motor vehicle accidents. The Victim Compensation Fund is a fund established by the Protection for Motor Vehicle Accident Victims Act, BE 2535, 1992, to provide compensation and benefits to victims of motor vehicle accidents who are not covered by any insurance policy or who are unable to claim compensation from the liable party. The Victim Compensation Fund is administered by the Road Accident Victims Protection Company Limited, RAVPC, a state-owned enterprise under the supervision of the Ministry of Finance. The Victim Compensation Fund is financed by contributions from vehicle owners based on the type and size of their vehicles. The contribution rates range from 50 baht to 600 baht per year. Vehicle insurance companies are also required to contribute 10% of their premiums to the Victim Compensation Fund. In addition, vehicle owners are required to purchase compulsory third-party liability insurance, which covers bodily injury and death caused by motor vehicle accidents up to a certain limit. The compulsory insurance is provided by private insurance companies that are licensed by the Office of Insurance Commission. Section 14. This section prohibits a member of the National Health Security Board from holding a position in the Quality and Standard Control Board simultaneously. Section 15. This section sets the term of office for the members of the National Health Security Board at 4 years and allows for reselection or reappointment for no more than 2 consecutive terms. It also provides for the continuation or replacement of members in case of vacancy or expiration of term. Section 16. This section lists the causes for vacating office for the members of the National Health Security Board, such as death, resignation, bankruptcy, incompetence, imprisonment, or removal by the Council of Ministers. Section 17. This section stipulates the quorum, voting, and procedures for the meetings of the National Health Security Board. It also requires members to disclose any interest in the matters under consideration and refrain from voting. Section 18. The National Health Security Board, NHSB, has the power and duties to establish the standard of health service, advise the minister, prescribe the types and scope of health service, manage the fund, support local government organizations and community organizations, produce annual reports, and perform other duties as required by law or entrusted by the Council of Ministers. Section 19. The NHSB has the power and duties to oversee and ensure that the National Health Security Office, NHSO, functions in accordance with the objectives, policies, and plans set forth by the NHSB. Section 20. The NHSB has the power to appoint subcommittees to perform duties as entrusted by the NHSB. Section 21. The NHSB shall appoint an audit subcommittee to review the financial management and operation of the NHSO and report to the NHSB at least once a year. Section 22. The NHSB, or a subcommittee, has the power to request or order any state agency or relevant person to submit information, statements, documents, or evidence for its consideration. Section 23. The NHSB and the subcommittee shall be provided with meeting allowance, travel allowance, and other expenses as prescribed by the minister. Section 24. The NHSO is a state agency, with the status of a juristic person under the supervision of the minister. The affairs of the NHSO are not subject to some labor laws, but its officials and employees are entitled to remuneration and benefits of no less than those laws. Section 25. The NHSO is located in Bangkok or a nearby province. The NHSB has the power to establish, merge, or abolish branch offices or entrust other agencies to perform the duties of a branch office. Section 26. The NHSO has the power and duties to be responsible for the administrative affairs of the NHSB, collect and analyze information, create records of beneficiaries and service units, manage the fund, disburse health service expenses, examine documents and evidence of claims, arrange for people to have regular service units, supervise service units, hold ownership and property rights, charge fees or service fees, entrust other organizations or persons to undertake its affairs, produce annual reports, and perform other duties as provided by law or entrusted by the NHSB. Section 27. The properties of the NHSO are not liable to attachment and sale in execution of a decree. Section 28. The National Health Security Office can own, manage, use, and benefit from its immovable properties that are acquired by donation, purchase, or exchange with its income. Section 29. The National Health Security Board shall request an annual budget from the Council of Ministers for the administration of the National Health Security Office. Section 30. The National Health Security Office shall keep and allocate its budget according to the National Health Security Board's rules, design its accounting according to the international standard and the National Health Security Board's format and rules, and arrange for an internal audit of its finance, accounting, and procurement. Section 31. The Secretary-General of the National Health Security Office is responsible for the administration of the office and acts as the superior of all official and employees. The National Health Security Board shall select, appoint, and remove the Secretary-General according to the rules and criteria prescribed by the Board and the Act. Section 32. The Secretary-General of the National Health Security Office shall have suitable qualifications and adhere to certain criteria such as being of Thai nationality, able to work full-time for the office, not being bankrupt, incompetent, or imprisoned by a final judgment, not being a political official or a member of a political party, not having been dismissed or discharged from a state agency or a public company, and not having any interest in a juristic person that is a contract party, or a partner of the office. Section 33. The Secretary-General of the National Health Security Office shall vacate office upon death, resignation, being disqualified or failing to fulfill the criteria in Section 32, being sentenced to imprisonment by a final judgment, being absent from 3 consecutive meetings of the Board without a reasonable cause, being removed from office on the ground of negligence of duty, misconduct, or being terminated of the employment contract. Section 34. The Secretary-General of the National Health Security Office shall hold office for a term of 4 years and may be reappointed, but not for more than 2 consecutive terms. If the position becomes vacant or the Secretary-General is unable to perform duties temporarily, the Board shall appoint one to the office to act in place of the Secretary-General. Section 35. The Secretary-General of the National Health Security Office shall be regarded as a state officer holding a senior-level position, and shall be prohibited from undertaking a business of conflict between personal interest and public interest, pursuant to the Organic Law on the National Counter-Corruption. Section 36. The Secretary-General of the National Health Security Office shall have the power and duties to recruit, appoint, promote, demote, reduce salary or wage, impose disciplinary punishment, or dismiss officials and employees of the office according to the Board's rules, issue rules or notifications in relation to the operation of the office, represent the office in respect of external affairs, and authorize any official of the office to perform specific duties in his or her place, according to the Board's rules. Section 37. There shall be an audit office under the National Health Security Office to act as the Secretariat Office directly responsible to the Audit Subcommittee, and to report to the Secretary-General according to the Board's rules. Section 38. There shall be a fund in the National Health Security Office called the National Health Security Fund, with the objective to support and promote the provision of health service by service units. The fund shall be spent in a manner that considers the development of health service in the areas where service units are inadequate or not properly decentralized. Section 39. The fund shall consist of money allocated from the annual appropriation, money from local government organizations, income from the provision of health service, administrative fines, money or properties donated or given to the fund, interest or a benefit accrued from the fund, and other contributions as specified by law. The fund shall not be remitted to the Ministry of Finances and National Income, The Board shall request a budget for the fund from the Council of Ministers based on the opinions of the Quality and Standard Control Board, and the financial accounting and property list of the office. Section 40. The receipt of money, payment, and custody of the fund, including benefit seeking from the fund, shall be according to the rules prescribed by the Board. Section 41. The Board shall earmark no more than 1% of the budget to be allocated to service units for financial assistance in case where a beneficiary is damaged by the medical treatment where no wrongdoer is identified, or where the wrongdoer is identified but the beneficiary has not received compensation within a reasonable period of time, according to the rules prescribed by the Board. Section 42. In case where a beneficiary is damaged by the medical treatment, where the wrongdoer is identified, but the beneficiary has not received compensation within a reasonable period of time, the office shall be entitled to take recourse with the wrongdoer after paying preliminary aid to the beneficiary. Section 43. Within 3 months from the end of the fiscal year, the Board shall submit to the Council of Ministers a balance sheet and report on income and expenditures of the fund certified by the Office of Auditor General. The Minister shall present such balance sheet and report to the Prime Minister for further submission to the House of Representatives and the Senate and arrange for its publication in the Government Gazette. Section 44. The Office shall arrange for the registration of service units and networks of service units, and publicize information thereof to enable people to register for regular service units of their choice. Sure, I can summarize the Section 44 to 53. Here is the summary. Section 44. The Office shall arrange for the registration of service units and networks of service units, and publicize information thereof to enable people to register for regular service units of their choice. The registration and publicity shall follow the rules prescribed by the Board. Section 45. A service unit shall have the following duties: provide health service of quality and standard, respect personal rights, human dignity and religious beliefs, provide accurate health service information to individual beneficiaries and their relatives or intimates, maintain confidentiality of the beneficiaries, and establish a system of health service data. The service unit shall provide health service, and establish a system of health service data according to the rules prescribed by the Board and the Quality and Standard Control Board. Section 46. The service units and networks of service units registered under Section 44, and the service units that beneficiaries are referred to, shall be entitled to receive health service expenses from the fund according to the rules prescribed by the Board. The rules for determining health service expenses shall take into account the opinions of service providers and beneficiaries, the cost estimates for the treatment of diseases, the salaries and personnel remuneration of the service units, the differences in missions of the service units, and the diversity of beneficiaries and sizes of the areas under responsibility of the service units. Section 47. The Board shall support and coordinate with local government organizations, and prescribe rules entrusting them to implement and manage the national health security system at the local level with the expenses provided by the fund. Section 48. There shall be a board called the Quality and Standard Control Board consisting of representatives of state agencies, professional councils, private hospitals, local government organizations, health professionals, non-governmental organizations, and experts appointed by the Council of Ministers. The members shall elect among themselves one member to be the chairperson. The Secretary-General shall be the Secretary of the Quality and Standard Control Board. Section 49. The provisions on holding position, term of office, vacation of office, and meeting of the National Health Security Board shall apply mutatis mutandis to the Quality and Standard Control Board. Section 50. The Quality and Standard Control Board shall have the power and duties to control and promote the quality and standard of service units and networks of service units, ensure the quality and standard of health service that exceeds the scope under Section 5, prescribe measures for controlling and promoting quality and standard, recommend cost estimate rates for all diseases, prescribe rules for filing complaints by persons whose rights are violated by the service, report results of the inspection, and the control of quality and standard of service units and networks of service units to the Board, enhance public participation in the inspection, provide financial assistance to the beneficiaries who are damaged by the medical treatment provided by service units, support development of an information dissemination system for use by the public, and perform other duties as prescribed by this Act. Section 51. The Quality and Standard Control Board shall have the power to appoint a subcommittee to consider or perform duties as entrusted by the Quality and Standard Control Board. The provisions on meeting, procedures of meeting, and performance of duties of the Subcommittee on National Health Security shall apply mutatis mutandis to the Subcommittee on Quality and Standard Control. Section 52. The Quality and Standard Control Board and the subcommittee shall have the power to request a state agency or order any relevant person to submit a written statement of facts, give a verbal statement, or furnish documents and evidence to support their deliberation. Section 53. The Quality and Standard Control Board and the subcommittee shall be provided with a meeting allowance, travel allowance, and other expenses in the performance of duties as prescribed by the Minister. Section 54. In performing the duties under this Act, a competent official shall have the power to enter the premises of service units and networks of service units during official hours to inspect, inquire into facts, examine properties or documents, take photographs, copy or bring relevant documents for review, or take any other action deemed reasonable to obtain the facts. If a wrongful act is detected, the competent official shall have the power to impound or seize documents, properties, or materials for use as evidence. The operational procedures of the competent official shall follow the regulations prescribed by the Board or the Quality and Standard Control Board. Section 55. In performing the duties, a competent official shall present his or her identification card to the relevant persons. The identification card shall be in accordance with the format specified by the Minister in the Government Gazette. The relevant persons shall facilitate the competent official in performing his or her duties to a reasonable extent. Section 56. In performing the duties under this Act, the competent official shall be regarded as a competent official pursuant to the Criminal Code. Section 57. In case where an inspection by the office reveals that a service unit fails to comply with the health service standard as required, it shall report to the Quality and Standard Control Board for appointing an investigation committee to consider the matter. The investigation committee shall consist of members with suitable qualifications and no interest in the matter, and shall have the duty to conduct investigation and provide opinions to the Quality and Standard Control Board. The investigation shall be completed within 30 days or extended if necessary. Section 58. In case where the result of the investigation indicates that a service unit fails to comply with the prescribed standard, the Quality and Standard Control Board shall issue a warning or an order for an administrative fine, depending on the intention of the Act, and notify relevant agencies to investigate and decide upon the allegation or incrimination against the health professional who may be responsible for the wrongful act. Section 59. Any beneficiary who has not been facilitated by a service unit in a reasonable manner, or according to his or her right to public health service, or has been requested for an inapplicable or excessive service fee, or has not received compensation for the damage from the medical treatment by a service unit, shall be entitled to file a request with the Office for Investigation. The provisions of Section 57 shall apply mutatis mutandis. If the result of investigation indicates that the service unit has committed the wrongdoing cited, the Quality and Standard Control Board shall issue a letter of warning, or a letter ordering the service unit to refund the surplus or inapplicable fee with interest. Section 60. In case where the wrongful act committed by the service unit is of a serious nature, or repeatedly committed, the Secretary-General shall report to the Quality and Standard Control Board for a consideration of revoking the registration of such service unit, notifying the Minister in charge of the law on sanatorium to proceed accordingly, notifying the governing minister to undertake disciplinary procedures with the administrator of such service unit, and notifying relevant agencies for investigating and deciding upon the allegation or incrimination against the health professional who is responsible for the wrongful act. Section 61. Any person who obstructs or fails to facilitate a competent official in performing his or her duties under Section 54 shall be liable to imprisonment for a term not exceeding 1 year, or to a fine not exceeding 20,000 baht, or to both. Section 62. Any person who fails to comply with an order of a competent official under Section 54 shall be liable to imprisonment for a term not exceeding 6 months, or to a fine not exceeding 10,000 baht, or to both. Section 63. Any person who fails to comply with an order of a competent official under Section 52 shall be liable to imprisonment for a term not exceeding 3 months, or to a fine not exceeding 5,000 baht, or to both. Section 64. Any person who gives false information, or conceals facts from a competent official under Section 52 shall be liable to imprisonment for a term not exceeding 6 months, or to a fine not exceeding 10,000 baht, or to both. Sure, I can summarize the Section 65 to 70. Here is the summary. Section 65. Any person who violates Section 45 paragraph 1, 2, 3, 4, or 5, shall be liable to imprisonment for a term not exceeding 1 year or to a fine not exceeding 20,000 baht, or to both. Section 66. Any person who violates Section 45 paragraph 2 shall be liable to imprisonment for a term not exceeding 6 months, or to a fine not exceeding 10,000 baht, or to both. Section 67. Any person who violates Section 7 or Section 8 shall be liable to a fine not exceeding 5,000 baht. Section 68. Any person who violates Section 55 paragraph 2 shall be liable to a fine not exceeding 5,000 baht. Section 69. Any person who violates Section 55 paragraph 3 shall be liable to a fine not exceeding 10,000 baht. Section 70. In the case where the offender under this Act is a juristic person, the managing director, manager or any person responsible for the operation of such juristic person, shall also be liable to the punishment provided for such offence, unless it can be proved that such offence was committed without his or her knowledge or consent.